was referring to the simple single pole-to-pole attachment in the prior design and comparing it to the new, more complex arrangement introduced by the invention, where one has both north and south pole of the implant magnet being presented to the external component, which also presents a north and south pole. And I was making my point by reference to the diagrams that we've inserted between paragraphs 43 and 44 in our skeleton, coloured up with the green and red to illustrate north and south pole. And those diagrams illustrate the different arrangements, but I wanted to make sure that my lady and my lords understood that what we're depicting here are disc-shaped magnets looking side on in both cases. So to be clear, the left-hand side has magnets of the kind shown by the judge at paragraph 44 of his judgment, and the right-hand side has those shown at paragraph 45 of the judgment. So they're disc-shaped and we're looking side on. And I referred a couple of times to the added complexity to the attachment introduced by the invention. And it's not just that there are two poles in each magnet involved in the attachment instead of single pole to pole. It introduces a need for the magnets in the invention to be properly aligned rotationally. Hopefully my lady, my lords will appreciate that in the simple case, the left-hand side of the diagram, it doesn't matter how those two magnets are rotationally aligned in respect of each other, because the totality of the top surface is one pole. So that's the natural way one would consider a magnetic attachment. But when we're bringing together two magnets of the kind shown by the judge in paragraph 45, rotational alignment becomes a factor and indeed important. And we've shown them on the right-hand side of our diagram, where we're looking at it precisely with the orientation of the magnets north-south across the page, each one in opposite directions. But of course the discs could be presented to each other where they're not precisely rotationally aligned like this. If one were to consider the magnets oriented with more of the green half in view as we're looking at it, you would get not just less magnetic attraction because you've got less north pole lined up with a south pole, but a bit of positive repulsion where some of the north pole is lined up with the north pole on the external magnet. And you don't have any of that with the simple pole-to-pole arrangement when in the old design. And I just wanted to make sure that my lady and my lords fully grasp what I was talking about when I was talking about the difference in the mode of magnetic attachment. My lord's looking puzzled at me.
No, I understand perfectly everything you say. What I don't understand is the relevance of it. I mean, this is no more difficult than a magnetic stirrer technology which dates back to, what, the 1960s, and was found to be common general knowledge.
No, the reference of it is the way in which you're naturally thinking when you want a magnetic attachment. It's all to do with when you're looking at achieving a magnetic attachment, are you even thinking of doing the right-hand side? That's the relevance of it, my lord. Are you even thinking of it? And that's why I showed my lady, my lords, yesterday, that bit where the judge put it in terms of, is it being taught as required? And I said that that betrayed a thinking on the part of the judge that you actually be thinking of not doing it unless you're told you must. And it's quite important in the context of where it's just a feature that everybody always had, and it's the natural way to do it in my submission. You're not thinking that you're going to change it to this more complicated arrangement. So that's the relevance. Now, yesterday, when I came to the end of my submissions, I realised that I really ought to get on and show my lady and my lords how this was dealt with in the EPO. Because it's important, we say, it's consistent with my approach to Zimmerling, not my friends. Now, before we open that up, can I just address a suggestion that my friend makes, paragraph 8 of his skeleton, that we're incorrect to say the same obviousness case was rejected. He suggests the arguments were different, we'll see about that, but he also makes the point that, of course, in the EPO they didn't have the same evidence. They didn't have the evidence of Professor Parker. And of course it's true that evidence is never exactly the same, and submissions can never be verbatimly repeated. And sometimes the court just takes a different view to that the EPO does. That is a feature of the system we have allowing a granted patent to be attacked in national courts. I accept all of that, but it does not mean that it's wrong to say that the same obviousness attack was rejected. And I draw specific attention to the fact that we are not here considering a case of weighing up experts' reasons for a skilled person taking steps in a particular direction in the light of the teaching as a starting point. We're arguing about something more fundamental. What that starting point is, what the whole picture presented by Zimmerling is. Does Zimmerling teach an idea of changing orientation of magnetisation or not? My friend says he does. I say not.
Mr. Speck, I've been wondering about this. And since you put it that way, it's an opportune moment for me to ask you a question that's been going through my head most of yesterday afternoon. You will know that there is a distinction between the true construction of a document, which is a matter of law for the court, and the question of what a skilled person would think, having read a document, which is a question of fact as to which evidence can be given. And it seems to me that what you just described is certainly not only a question of construction, it no doubt involves questions of construction, but it is also a question of what the skilled person would think when they've read Zimmerling, in which case it is a matter for evidence, or can be a matter for evidence.
It can be a matter for evidence with reasons as to why you would think that or not.
And the ultimate decision of the court is a question of fact, having construed the document.
In the sense that if there are, for instance, if there was cross-examination that had put the point in terms of changing magnetisation and a reason why you would perceive it as a change of magnetisation, I accept the thrust of what you're saying. I do accept the thrust of what you're saying. But that's not what's happened here. What's happened here is it's been argued, because the cross-examination talks about magnetising something a particular way, that means changing. And it doesn't. And you can look at Zimmerling and there's nothing there about changing at all. So we're really, I do accept what my Lord says about it quite possibly having that, but not in this case.
Okay.
We're arguing more fundamentally about what the document does disclose, and if it said that it discloses more, where's the evidence that shows you that?
Sure, I understand that. But
So
just before you go to the EPO, part of the point that I'm seeking to ensure we're clear about is that is a distinction between the approach in this court and the EPO, in the sense that the EPO doesn't look at it in quite the way you and I have just discussed.
Well, they might do if you've got some written evidence filed.
They're not very interested in expert evidence in a case like this, are they, Mr. Speck?
I understand that they're more focused on the document. I understand that.
Yeah.
But your Lord, my lady and my lords would still be interested to see.
Absolutely.
And I'm going to show you that it's not just that they take a different view as to what is obvious to do. It's their understanding of what Zimmerling is presented that's different. And so the crucial issues, does Zimmerling teach an idea of changing orientation of magnetisation or not? Does it teach an abstract solution that magnets can rotate in a magnetic field to a line? Or is it, as I suggest, more than that? It's about keeping the dipole direction the same when in use and rotating it away when not. And it does so by providing a differently shaped magnet. So in this case, it is instructive to see the substance of what I'm saying about the difference in the level of detail of what you see in Zimmerling is accepted in the EPO. Can we take it up? It's in the supplementary bundle. And it's towards the back, tab 27. And just to orient my lady and my lords, Zimmerling is D1. You see that on the first page of the decision, which is 251 of the bundle. D1 is identified with the number, and that's what Zimmerling is. So down towards the bottom of the page. And obviousness inventive step is addressed at paragraph 36 onwards. That's page 13 of the decision, 263 of the bundle. And we see at 37, Zimmerling is described as concerned with MRI compatibility issues. Towards the second half of this paragraph, it explains it suggests a solution of the implant magnet being allowed to turn, possibly with some restrictions, into the external magnetic field lines. And it goes on at the end of the page. It proposes concrete solutions, for example, employing one or more magnets of spherical shape. Now, the detail of the obviousness case over Zimmerling is picked up at paragraph 42. And we can see it was put two ways in the EPO. 42 is where they pick it up and explain the case advanced. First, starting from the general teaching, so not linked to any specific embodiment at all. And secondly, starting from the figure 12 embodiment. In that case was not a way of advancing it here, but the first obviously was. And the following paragraph deals with that first way of putting the case on the general teaching. We see the argument of AB summarised in 43 and 44, and it's this: allow the implant magnet of whatever shape to turn, possibly with some restriction, into the external magnetic field. And the argument is to take that fragment of the sentence from 7, page 7, as recorded in paragraph 44. The argument is, according to GB, that you take that and you arrive at the implantable device within the claim. And we see what the board thinks of that. It deals with it in paragraph 45, makes the point that the teaching of Zimmerling is that the shape is not important as long as the implanted magnet can turn so as to line its dipole with the external field. Please note that, my lady and my lords. It's not saying absolutely any shape will do. It's saying shape actually matters, but it's okay as long as it's a shape that allows it to be turned. And the next paragraph...
Sorry, can I just make sure I think I misunderstood that paragraph. When it says external magnetic field, it's talking about the MRI field, not the external piece of the cochlear implant.
Yeah, absolutely. Yeah. The external field, when we're talking about rotating to align with an external field, one's usually talking about what you do when it's not in use, and it's the MRI. Yeah. What I say about what they're saying there, and you'll see later on that it clearly understands Zimmerling as about shape, is they're saying shape does matter. It doesn't have to be a particular shape. Shape isn't important as long as it's a good enough shape to allow it to rotate. The next para 46, explains the skilled person would see the concrete solutions in the different embodiments, none of which correspond to the embodiments covered by the claim. And para 47 explains that the skilled person would understand that making the disc-shaped magnet described in the prior art section of Zimmerling rotatable in the plane of the housing would not solve the MRI incompatibility problem, given the orientation of its magnetic pole, and would be understood to teach away from using disc-shaped magnets. Paragraph 48 is absolutely key. It says, absent any hint in Zimmerling, the Lord explained that the skilled person wouldn't consider changing the direction of the magnetic dipole from perpendicular to parallel to the surface of the disc, instead of changing the shape of the magnet as taught by Zimmerling. We just pause there. What do you get from that? The paragraph recognises that Zimmerling is first about keeping the magnetic dipole perpendicular to the head, doesn't teach changing its orientation, and secondly, it is expressly recognising Zimmerling is about changing the shape of the magnet. It specifically says Zimmerling teaches to change the shape. And doing that obviously allows for temporary rotation away from that problematic orientation. These are all key parts of context stripped out in the judge's approach, as I've said, but the EPO did not ignore it. The patent is about doing something different instead of changing shape, changing the direction of the dipole to be parallel to the surface of the disc. And Zimmerling does not teach changing the direction of magnetisation, contrary to what my friend asserts. So you see from paragraph 49, this case based on the general teaching is rejected. And it is in substance the same case the judge accepted. And my submission to my lady and my lords is the difference between the EPO and the judge is the EPO's more complete appreciation of the context and purpose of the Zimmerling disclosure. They recognise that it's about keeping the dipole in the orientation that it would be naturally, the old design, and changing the shape to allow for that temporary rotation away. As I've said, it's not simply a case where some experts come along and give an explanation of why something would or would not be done given the disclosure of the prior art document. It's more fundamental. It's a difference as to the appreciation of the complete picture one gets from the disclosure to start with. Now, can we look for good measure as to how the board dealt with the second way the case was put, based on the figure 12 embodiment? That's addressed from paragraph 50. Figure 12 was a spherical magnet, and the argument was pretty crude. To consider flatten it, you see that from paragraph 51, and it says that you carry out necessary adaptations and arrive at the invention. And what is obviously covered up in the necessary adaptations is changing the direction of the dipole, so it's not perpendicular to the side of the head. The substance of the argument is squash the sphere and flip the dipole. And the board make the point in paragraph 52 that the argument of considering a disc magnet was simply to return to Zimmerling's own starting point in terms of MRI compatibility, the disc magnet with perpendicular dipole. Basically, an argument of throwing away the suggestion of the document and starting from it, the document's own starting point. And that's actually, as I said to my lady and my lord yesterday, what happens in this case when the judge says what you decide to do looking at Zimmerling is first decide to keep the disc magnet, and then as a second stage, having done that, you decide to flip the dipole. That first step is throwing away Zimmerling and going back to Zimmerling's starting point itself. And so in the EPO, the case based on Zimmerling was rejected, and I rely upon it not simply as the TBA reaching a different conclusion, but because in my submission they are recognising the key aspects of context and purpose at play in Zimmerling, which is a key difference, and is just lost if you read Zimmerling, or take Zimmerling as teaching change the direction of magnetisation in the way that my friend alleges, or you go to some alleged solution which is at a level of abstraction that it teaches that implant magnets can rotate to align with external field. That basically is just the law of the physical law of magnetism. Zimmerling is not about changing magnetism, direction of magnetism at all, and the solution of Zimmerling is more than that, as the EPO recognised. Now, can I very briefly end by just addressing my friend's answers to our points?
Sorry, Mr. Spade, forgive me. Just in the EPO, as I understand it, the diametrically magnetised disc-shaped magnets that were playing a part in the EPO case were in D2.
I think you might.
I can't find anywhere in the decision a finding that a diametrically magnetised disc-shaped magnet was part of the common general knowledge. I can't see that anywhere. I mean, if I got that wrong, please tell me.
It's definitely not said. Yeah. But it's not rejected on the basis that it's not part of the common general.
No, well, it doesn't appear to be something that's being addressed at all.
Yeah, your lordship will have picked up that it was an attempt to mosaic.
Yes, I can see that. Yes, and that failed. Yeah.
So I think but that wouldn't work here anyway.
Exactly. Thank you. Sorry.
Can I finish on this attack on the judge's approach to Zimmerling by answering what my friend says are his answers to my criticism? He basically makes 4 points in paragraph 45 onwards. They're in fact in substance only 2 points. And the first 2 points are basically an argument that my characterisation of Zimmerling is wrong, and the third and fourth points are basically suggesting I've changed my case from that advanced at trial, one of which is directed to the expert introduction to Zimmerling that I addressed yesterday in response to a question from my Lord Justice Arnold, and the other is a point on our submissions. Can I deal with the first two first? So the suggestion that I'm mischaracterising Zimmerling, it's really no more than we've covered already. The essence of what is suggested in paragraph 45 is that Zimmerling teaches changing the conventional direction of the dipole to what he calls a diametric, not axial. That's a really important part of my friend's case, and it's simply indefensible. We've covered already Zimmerling doesn't change the dipole in the sense of its direction being perpendicular to the side of the head. It suggests changing using a shape that allows it to be rotated away when not in use. It suggests a new shape, and here, when in paragraph 45 my friend is expressly referring to other than a sphere, he obviously means a cylinder. But as we covered already yesterday, Zimmerling is not about or expressed as changing the magnetisation of a cylinder, or indeed any shape. Can't be, because the shape hadn't been used before. The second point, my friend's paragraph 46, is really adds no more. Zimmerling avoids the problem of torque by going to an arrangement where the magnet can accommodate rotation to at least partially align with the magnetic field. And it does so only in the context that I've identified to my lady and my lords. The well-known mode of attachment with the orientation of the dipole out, and you rotate it away. And we've just seen the EPO explain it doesn't hint at adopting a different mode of attachment with the dipole never in that perpendicular orientation. So that's the first pair of points, basically trying to defend his way of looking at Zimmerling. Can I move to the second, which are points 3 and 4? And as I say, I've dealt with the one on the evidence yesterday. Can I dispatch the point he makes about our submission? So this is his paragraph 49. We see a passage from our closing set out there. Even looking at those 4 lines, you can see we are recognising that what's going on in Zimmerling is a temporary thing, because it's explained that the magnet is free to rotate when the patient is in the MRI and the attachment magnet has been removed. But you'll see that hammered home if you see the document as a whole. It's supplementary bundle tab 21. The section starts at the foot of page 189, where you see the heading, the fundamental difference between Zimmerling and the patent. And you see at the end of para 59, we explain here that we're addressing the fundamental concept that can be distilled from Zimmerling. So seeking to engage with the way that my friend looks at the case by not looking at an individual embodiment but across them. We have the familiar diagram of the torque problem at the beginning of the next page with an explanation of it in 61. Then there is the short one-sentence paragraph 62, which is the text quoted by my friend. So 62 is the bit that he's set out. The explanation goes on, where figure 10 of Zimmerling is reproduced to illustrate our point. That's a figure that has the conventional external magnet shown. Please note in 65, when the external magnet is removed, Zimmerling's sphere is free to rotate in any direction. This enables its dipole to move from its attachment position to align with any external MR field without producing any material force on the implant housing. Couldn't be clearer. It's the conventional attachment position, but when that's not in use, it can rotate away. In other words, it's temporary rotation. Then there's the mention of the smaller multisphere example, figure 4b, and reference to the cylinder example through the next page. And can I pick it up at para 71 on page 193, the paragraph says, importantly, and it says that because what's in it is important, it's common ground that all of the teaching of Zimmerling is based upon the CGK attachment magnet. That doesn't change. We explain in the rest of 71, it's when the external magnet's taken away and the patient goes in the MRI that the magnets are allowed to rotate. And 72 is absolutely key. The realisation of the pattern is different. It's based upon a realisation that maintaining the axial attachment orientation, i.e. keeping the conventional mode of attachment, is not the right way to achieve a thin and simple MRI compatible solution. It's precisely the case that I'm advancing to my lady and my lords. We haven't changed our case at all. And in fact, we explain in paragraph 69 of our skeleton, it's not just my clients that recognised that Zimmerling was concerned with shape. Paragraph 77 of my friend's opening skeleton, directed to Zimmerling, is doing the same thing. That paragraph is actually reproduced in the document at tab 19 in the same bundle that my lady and my lords have. The key point is my friends identify Zimmerling teaches that the torque issue can be alleviated by use of a rotatable internal magnet which needs to be free to rotate such that it can at least partially align. That's subparagraph 1. And subparagraph 3 says a number of different shaped magnets could be used to achieve the rotation. And it goes on to point out that 3 shape designs are exemplified. On our side, we have some difficulty as to how my friend can now be saying that Zimmerling teaches that shape just doesn't matter. The opposite's true. And we say my friends are recognising that shape matters in this paragraph. The fact that it doesn't say only one shape or only 2 shapes, it's clearly talking about rotation achieved by getting a suitably shaped magnet. Shape is what you focus on. Now, to complete, my friend's answers on Pozzoli are completely dependent upon these points again. I have in mind what he says in paragraph 63 of his skeleton. The 2 groups of points that I've just addressed and explained why they're wrong completely underpin my friend's answer to our case on Pozzoli. We see reliance upon the contention that Zimmerling is a teaching of changing dipole orientation in subparagraph 1. Reference to this alleged core teaching being common ground between the parties and experts is subparagraph 2. And subparagraph 3 is the suggestion Zimmerling is not about shape because it's not limited to shape. None of those contentions is right, as I've explained. And my friend characterises what he calls the bottom line in paragraph 64, a suggestion that it was obvious to try what they frame the Zimmerling idea using the CGK disc-shaped magnet. Our point, my lady and my lords, is the judge has gone wrong at the first step of identifying the so-called Zimmerling idea. What does my friend mean when he refers to the Zimmerling idea? He avoids saying it here. I'm hoping we have an explanation of it orally. One assumes he means the thing identified by the judge as a solution proposed by Zimmerling, i.e. the second limb of that paragraph 206. That is, that implant magnets can rotate to align with an external magnetic field. As I've explained to my lady and my lords, it's actually a statement of the problem too, and it strips Zimmerling and its disclosure of all context and technical purpose, particularly as to the specific rotation accommodated and how it is achieved. That's all I wanted to say on that part of the case. I can deal with long felt want very briefly unless my lady and my lords have any questions for me on that aspect of the case. It's a secondary consideration, of course, but nonetheless an error of principle has been made by the judge my clients are entitled to complain of. And it's noteworthy, we say, that the thrust of my friend's answer in his skeleton on this point is basically to re-argue the issue, proffering reasons that may or may not be points to weigh in the balance. He even relies on the fact that my client recognised it as only secondary and treated it accordingly in a way the judge described as light touch. But none of what my friend says comes close to being an answer to the point that the judge applied too strict a standard for the point to be considered as satisfying the criteria identified in the cases for it to be relevant. And the point is this: where there's a long felt want, here a common general knowledge problem, with really unsatisfactory ways of dealing with it, and it remains unsolved, this may well be a secondary indicia of inventiveness. But one of the problems one must particularly guard of in a case such as this is that the statutory test is, of course, whether the claim covers something that's obvious to a skilled person over the state of the art, in practice often, and in this case meaning, over a particular piece of art. So in this case, we're arguing about whether it's obvious to a skilled person when they've got the piece of art. And so when you're looking at a failure of real-life people in the art to solve the problem, you need to keep an eye on whether this failure is probative of that statutory question. And the statutory question is the failure, or sorry, the point that we're concerned with is the fact that the failure to solve the problem, is that probative? It's irrelevant unless those that failed were aware of the publication, because you're just looking at a situation which is not your statutory question. They're not aware of it, it's not indicative of anything. And that was explained by Mr. Justice Pumphrey in Halliburton, and we can get that from the judgment itself. It's para 251 of the judgment, where the judge quotes it. So I'm in tab 7 of the core bundle. And it explains the consideration is a secondary one, and as I've said to my lady and my lords, I entirely accept that. 4 lines into the quote, we see the point I've just explained. The actual question is obviousness over each cited document. And he goes on and says failure by investigators is irrelevant to the question unless it can be shown that those who failed were aware of the publication. The point I was just trying to explain to my lady and my lords. And he goes on to make a point about the situation when a publication itself is not relied upon, but a common general knowledge alone case. And he makes the point that you need to know that the investigators were possessed of the common general knowledge. What he's not saying, can I just make a point before we move on, because of the way that my friend seeks to answer this. What he is not saying there, where he talks about common general knowledge, he's addressing a case which is based upon common general knowledge. He's not saying there that where a publication is relied upon, it must be shown to be common general knowledge. He's not saying that there. He's saying the secondary point may be stronger in a case where it's not a publication but CGK itself, but you need to know the investigators were possessed of it. What Mr. Justice Pumphrey is saying about the ordinary case, based upon a publication that we're concerned with, is you need to know the investigators that failed knew of the publication. Now, the problem with how the judge dealt with it is that he appears to have taken that as requiring both that all of those trying and failed were aware, but also that their awareness was at a level he characterises as well aware. He appears to be elevating the requirement to something akin to the document being common general knowledge, something well known by all. And can I show you that? If we go forward to 257, we see the judge dealing with this. In the middle of the paragraph, the judge mentions that Zimmerling had been picked up by cochlear, so that's the third player of the 3, not the one, not a party to these proceedings. And of course, my clients were aware of it because it's our own contribution. So that just leads my learned friend's clients, A, B itself, who stayed conveniently silent. Anyway, having referred to Professor Parker not considering Zimmerling publication to be of any substance, and referring to the fact that others may have kept a close eye on documents like this, can only be relevant to the question really of whether AB was unaware. The judge went on anyway and said this was not enough to support the contention that the document was well known to all relevant parties in the industry, which he then says that means complying with the guidance in Halliburton that I've just shown you is difficult. Now, my learned friend refers to paragraph 257 and characterises this as a finding that the evidence was not sufficient to show Zimmerling was common general knowledge. That's his paragraph 67. We agree that's a fair way to characterise the standard the judge is applying. Totally agree. And in my submission, that is wrong in principle to require that. One doesn't need to show everyone was aware, or even that they were well aware. For example, you have an industry of 10 players and you can prove that 5 of them were aware of the publication. Each of them had considered it of no substance like Professor Parker did here. Even though it's now said to render obvious an important solution to a common general knowledge problem, that may well be probative. It needn't be shown that the other 5 also saw it.
Mr. Speck, I'm struggling to understand this argument because there's 2 questions in any argument over long-felt want. Firstly, was there a long-felt want at all? That's got nothing to do with any particular prior art proposal. Indeed. Then, if there is a long-felt want, you then look to the prior art in question and say, well, if that's supposed to provide the answer to this long-felt want, how come it doesn't seem to have led everybody to what was supposedly the obvious answer, particularly if there's a reasonable gap of time? Sure. Now, your argument in this court is all about question 2. But as we can see from 258 through to 260, the judge's reasoning is primarily based on question 1. He doesn't find that there is a long-felt want in the first place. And therefore the question as to why did nobody do it in the light of Zimmerling, published 7 years before, doesn't arise.
Well, what I'm addressing, he's also dismissing it. He's dismissing it. What he's actually found, my lord, is that this was a common general knowledge issue. Right?
Look at 260. There is simply not enough relevant information to give rise to a finding of long-felt want. That's the conclusion.
Yes, well, that's a shorthand that he's using for this whole issue.
No, I don't agree with you.
Well, that's
if you look at the reasoning in 259, it's all about what people were doing and whether this was a pressing problem or it wasn't a pressing problem.
But he's also found that it's a common general knowledge problem, and he's explained how you have to deal with it with surgery. Now, what my learned friend relies upon, and the thrust of what my lord is putting to me, is that people were looking at other things as well. I entirely accept that may be part of the picture. Entirely accept that. But it is a common general knowledge issue. So to suggest that there isn't a problem that everybody knows about and wants a solution to, can't be right.
It's the wanting a solution that's the problem. Yes, there could be a well-known problem, but if everybody thinks it's a problem that can be managed other ways, then there's no long-felt want.
Well, you've seen the way in which you have to manage it. You either had to have twice double surgery, or you had to wrap people's heads tightly. And the judge is clearly also dismissing it on the basis that he is suggesting that you need to show that everybody was well aware of the document. And that's wrong. And really what the point that my lord is putting to me is that if you exercise the assessment afresh, the points that about whether you're spending time looking at something else may come into the assessment. But my complaint is that this has been done by suggesting that I don't get over the hurdle of relevance because I have to show that all players in the industry were aware. You can't shy away from that, my lord, in my submission. The judge has clearly approached it on the basis that that's a requirement. Therefore, his assessment is flawed.
Mr. Spade, what I don't see in the judgment, and you may say this is part of the difficulty, I don't know. It'd be interesting to understand how it was put to the judge. He doesn't appear here to be saying, and I'm paraphrasing, Mr. Speck says that it's a common general knowledge problem and therefore satisfies the first limb of the long-felt want issue because people were doing surgery. I don't agree because so-and-so, or I do agree because so-and-so. It doesn't, as far as I can see, the judgment doesn't approach it that way. As far as I can see, and this is what my lord is putting to you, what I read 257 as doing is treating the fact that Zimmerling isn't common general knowledge as probative of the fact that this wasn't a common general knowledge problem in the relevant sense of being you needed a problem to do with fiddling around with cochlear implants to solve this problem. I don't know. You need to help me, but I can't see anywhere where the judgment is addressing the way you're putting the case now.
Well, it's definitely, with respect, my lord, it can't be. He's not saying it's not a common general knowledge problem because one of the very first things I showed you when I stood up was that he held that it was.
But it's the question of the other solutions. Look at the last sentence of paragraph 260, where he says various solutions available before the priority date continue to be used after the priority date, including in later commercialised MED-EL products. So the essence of the finding is that this was not thought to be a pressing problem because there were other ways of solving it, and those other ways of solving it continue to be used even after the invention had been made.
I understand that that's a factor. I understand, but it's a common general knowledge problem which actually requires quite serious, quite inconvenient ways of dealing with it. My complaint is the assessment has been done where part of what's been applied is a standard which is too high. That means there's an error of principle, my lord. Yeah. That means there's an error of principle, and it's not right to say that you have to have a common general knowledge document. And as I say, in the context here, where you have a common general knowledge problem with really unsatisfactory ways to deal with it, basically 2 lots of surgery or wrapping somebody's head tightly, those are the ways that it's dealt with. That's why I showed you right at the beginning. That's what you do. You can do some of the devices were designed so as to be available, so that you could take just the magnets out by surgery. So when I talked about surgery, you could either be taking the whole thing out, or you could just be taking out they had removable magnets. So you had a less invasive surgery, but you still had surgery, and you saw that finding that the judge made saying surgery is to be avoided. It's a secondary factor, but it has been dealt with on the wrong footing in my submission. That's why I said at the beginning, I don't overplay the point, but there is an error there. I've got to the end of my note, unless my lady and my lords have any other questions that you have.
No, thank you very much indeed. Yes.
My name. My lords, well, this is an appeal on obviousness, and the warnings in respect of such appeals are extremely well known, and we say there has been no error of approach or principle here to justify this court reopening or overturning the finding. We say the judge, and I'll show you, understood the nature of the invention, the teaching of the alleged invention, the teaching of Zimmerling. He displayed no hindsight and properly assessed long-felt want. Now, the EPO came to a different conclusion on inventive step, but it did so on different evidence.
What, did it have any evidence at all?
Well,
On
it
the
didn't.
face of it, didn't.
It didn't. My lord is correct. And indeed, I'll come to it. They did it through the, if I may put it this way, the four corners of Zimmerling, but without any evidence around it. Now, we say that when considering why the judge came to the decision that he did, it's important to keep in mind from the outset three underlying factual matters which were important to his decision, but were not before the EPO. And the first is the evidence for him that a skilled person reading Zimmerling in 2010 had a real incentive to keep the shape of the magnet in the implant a disc shape. Now, in the years before 2010, there'd been a huge amount of work in obtaining the best design for the implant in terms of its shape, dimensions and size, and the disc fit perfectly in that implant and helped to ensure it had a flat base which avoided the clinical problem of unnecessary drilling of the skull from the implant. And the evidence was that nobody would wish to lose that unless there was real clinical benefit obtained. Now, that is recorded in the judgment in paragraphs 51 to 57, and my learned friend took you to that yesterday, and I won't go back to that. But there is a piece of evidence which was before the judge which I would like to take you to, because it shows that the disc shape was also important to the primary functioning of the device. And my lord, and my lady and my lords will realise that although we have been focusing the last day and a half on the MRI compatibility, which is when somebody who has one of these implants has to have an MRI, the primary function of these devices is for hearing and the electrical impulses that are then understood by the brain. And that was discussed by Professor Parker, and if my lady and my lords would take the supplemental bundle, tab 15, and go to page 162, this is his second report. And he was explaining here the impact of the disc shape on the workings of the cochlear device itself. And he starts at the top of the page, it's the end of paragraph 38, that the skilled medical device engineer might not be part of the same team designing the coil, but they would, and that's the radio frequency coil, but they would know that the best way to minimize impact on the known and functional coil designs in the products on the market at the priority date was to maintain the size and shape of the magnet in the component. Then he goes on to say the disc-shaped magnet used in all the state-of-the-art devices at the priority date was therefore not a coincidence. It represents the best use of available space in such an implant system, maximising the amount of magnetic material that can be included, which is important, of course, for attachment. And he goes on, and keeping that material a uniform distance from the coil system, which is the RF coil system. Now that evidence those facts were, of course, not something that the EPO had to consider. Now, the second important point is a common general knowledge issue, and that's the knowledge that if a skilled person wants to rotate a disc in a magnetic field, he knows he can, or he or she can, and that one just orientates the dipole accordingly. And importantly, a skilled person does not need teaching to know this. Now, my learned friend repeated many times yesterday a mantra that all disc magnets used in cochlear implants were, at the priority date, were axially magnetized, and there was no hint of an alternative magnetic orientation. And that's correct, and that is because, prior to Zimmerling, there was no teaching that the magnet needed to do anything other than attach to another magnet. And for that, axial magnetization is perfect. But Zimmerling teaches the idea of rotating or allowing the magnet to rotate in the magnetic field at least partially to align with the external field lines of the MRI. And for that, the judge held, it would be known to the skilled person through his common general knowledge that could be done with a disc, but a different magnetization is needed. Now, my lords and my lady may realise that before the judge, my learned friend's client's case, that was not known. And that indeed their case was the idea of changing the dipole to allow rotation would be a eureka moment, and that was rejected by the judge. And to give the court a flavour of the sort of evidence before the judge, just one thing to look at, and then I'll take you to his finding. And that is in Supplemental Bundle 18, tab 18, at page 173B.
B.
173B. It should be at the very start of tab 18. It doesn't look like it is. That's right. It's a website first for magnets.
It is in mine.
Thank you, my lady. Apologies, my lord, Justice Birss.
Yep. In tab 18.
Tab 18, yes.
There was one of the updates.
It should be. It's an update, and it was
Tab
exhibit
17 of my paper bundle, but
Oh,
I've got it anyway.
I can only apologise.
Oh, no, not to worry.
The reason I go to is just to give you a flavour of the sort of evidence and why the judge made the finding he did. But this is a website from firstformagnets.com, and you can't tell it from this. It's actually the page before in the exhibit that hasn't been copied, but it's March 2010. And you see that they are talking there about diametrically magnetised magnets, and they're selling them on their website. And their second line is second paragraph, these magnets provide the key to rotational movement, and you can use them in applications where you want rotational movement. And that's a flavour of the sort of evidence that was before the court, and it led to his finding, which again is a finding that we say is an important one that my learned friend has rather skipped over, and that is in the judgment, paragraph 49 on page 90 of the core bundle. And at paragraph 49, the judge records that there was considerable debate about whether it was common general knowledge that a diametrically magnetised permanent magnet could rotate when interacting with an external magnetic field. And he records my learned friend's expert, Professor Swanning, saying that the skilled mechanical or electrical engineer would only have a couple of lectures on magnets and their properties and wouldn't know. And Professor Parker said it was all basic science. But then he goes on to say that actually Professor Swanning, although holding that view, some of his answers, and this is one of the criticisms the judge had of Professor Swanning, appeared blinkered and trying to justify his position rather than answering questions. And in the end, after the evidence, MED-EL had noted in closing that insofar as a magnet has a polarity, and you start exposing it to a field, the torques that are involved, and therefore the possibility to use them for rotation and the like, that is part of the common general knowledge. And at the end of this, the judge then said, the 3 lines up, I rely on the submissions of MED-EL and the evidence of Professor Parker to support my view that this is common general knowledge. And he then says that's going to be important later, and of course it is. And he comes back to that in paragraph 213 on page 128. Where at the end of para 213, it's the last 3 lines, there's a sentence that starts, the skilled person would understand. And he says the skilled person will understand the forces at work and know common general knowledge examples of diametric magnets operating to rotate in an external magnetic field. As noted above, I have assessed, therefore, that the key to rotating a permanent magnet in an external magnetic field is to have the magnetic dipole across the axis of rotation, that is diametrically magnetized, and this is common general knowledge. My learned friend haven't appealed these findings or even gone to them, but they are important when understanding the judge's ultimate determination. And the third finding, which I'd like to bring to the attention at the outset, which is important, concerns the dipole of the external magnet. Because, as my lady and my lords will appreciate, the claim requires that also to be parallel to the plane of the external housing, effectively diametric. And indeed, my learned friend yesterday and today has put a lot of his case on the fact that the pattern requires both the internal and the external magnets in use to be diametrically magnetized, and their dipoles remain parallel to their respective housings in use when they are connected. He calls that permanent orientation. And my learned friend went off into the figures, and he did so this morning in his skeleton, and that is in Core 5, page 43. His paragraph, just under his paragraph 43. And what he points out in these diagrams is, on the left, the conventional axial approach, where neither magnet is rotating and all they're doing is connecting. And he says, well, look, under the patent, both are no longer axially magnetized, they are diametrically magnetized. And the reason the lower one is diametrically magnetized is for rotation. The patent describes that as having dipoles parallel to the plane of the respective housings. But that's just another way of saying a diametrically magnetized disk magnet. And what we say one sees from that, and you get that also then from what the judge found, is what you see is they're complementary. So where you have the internal magnet axially magnetized, the external magnet is too, and on the right, where you have the lower magnet diametrically magnetized, the other complements it. And there was evidence on that. The reason being is that otherwise you would have unworkable offsets. And so what happens to the upper magnet simply follows as a knock-on effect to what you've done to the lower magnet. And the judge found that was obvious as a knock-on effect, and that was based on the evidence of both experts. And my lords will find that in the core bundle in tab 7, page 135. And that is at paragraph 242G. And at 242G, he says, 2 lines down, Professor Swanning accepted in cross-examination the choice of diametric implant magnet means the skilled person would choose a diametric external magnet without invention. This obvious knock-on impact was confirmed by Professor Parker. And he then referred to that again in his paragraph 263, which I'll come to. It's a paragraph which brought all his findings and reasoning together as a summary, and my learned friend has avoided going to it. But if you go to paragraph 263, my lady and my lords, on page 139, you will see this repeated at the end, 4 lines up. There's a sentence that starts, as part of this final consideration. My finding is that the choice of a matching external diametric magnet is also obvious for the reasons discussed above. It's a knock-on requirement from the earlier decision. And he's quoting there from the evidence. Now, the reason in my submission why these three underlying evidential matters are important is they mean that when the skilled person reads Zimmerling, and I'll come in a moment to the teaching of Zimmerling, but when the skilled person reads Zimmerling in 2010, he or she has the following in mind. First, he or she has in mind a real incentive to want to keep the existing disc-shaped magnet if possible. He or she does not want to mess with the overall design of the implant unless they really have to. Second, they know from their basic science and their common general knowledge that they don't have to. They don't have to change the shape of the magnet. They know from basic physics that they can enable rotation to align with the external fields of the MRI by making it diametrically magnetized rather than axial. It didn't need to do that before because it wasn't rotating in external fields. And finally, change in magnetization to the external magnet, making them both parallel to the plane of the housings, is merely an obvious knock-on effect. They know that's got to be done as well. This means that if a skilled person decides to implement Zimmerling using a diametrically magnetized disc-shaped magnet, the end result falls within the claims. And we say that there's nothing wrong in principle with this conclusion. There's nothing that stands out as something's gone wrong. It flows from the evidence before the judge. So turning, my lords, to the teaching of Zimmerling, and I'll deal with my learned French criticisms of the judgment that he made yesterday and today. And if my lords go to Zimmerling in the supplemental bundle tab 4, page 28. And there is no dispute that it is addressed to the same problem that the patent is addressed, and that is unwanted torque in an MRI. That is when the external magnet is not present, so the headpiece has been taken off, and the person with the implant has an MRI, and it's the torque on that implant. So it's got nothing to do with the actual problem. It's got nothing to do with the attachment with the external magnet. The external magnet is not there. And if we look on the second page, so so sup 29, supplemental page 29, there's no dispute that it has embodiments with its magnetic switch, and the judge, we say completely fairly, did not spend a lot of time on those because the evidence of both the experts, and I think all the experts, clinical as well, and the parties, was that the skilled person in 2010 would not be interested in the magnetic switch idea and protecting over voltage, for different reasons actually, but they would not be interested. And we say you can't criticise a judge for not spending time on embodiments which everyone accepts were of not interest. The important point is the torque-reducing embodiments were of interest, and that's why he focused on them. But even when we look at the magnetic switch and how it's introduced by Zimmerling at the bottom of that page, it is that you want a magnet free to rotate such that it is capable of aligning at least partially with an external magnetic field. And my submission is that phrase is a perfectly reasonable and apt way of describing the idea in Zimmerling. You then get over the page the discussions about particular shapes, but all the way through it goes out of its way to say that it's not seeking to limit to those shapes, and the first time we see that is in page 396. A magnet may, without limitation, be a sphere or cylindrical. And then at line 14 of that page, we have a paragraph, well, my learned friend said yesterday that we had rather plucked out and we're relying on? Well, it's the first paragraph that describes the non-switching embodiment, so we don't accept it's just been plucked out. And as I'll show you, the language is identical to how those embodiments are claimed in Zimmerling. That's claim 13. So we don't accept it's right that one can be criticised for saying you've sort of plucked out some phrase from a document when it's how the document itself phrases the invention it claims in claim 13, and I'll come to that. But as what we see there is again a very fair representation of what Zimmerling is about, that you need the magnet free to turn in the housing such that at least one magnet is capable of aligning at least partially with an external magnetic field. Then at 25, we again have spherical or cylindrical, and again may, no suggestion of must. That's line 25. Over the page, at the bottom, page 4, line 31, again we have the same phrase that they use throughout this document, that you want a magnet free to rotate, they either say rotate or turn, such that the magnet is capable of aligning at least partially with an external magnetic field. And then we can go through to the supplemental page number 34. There, line 26, we have the fact that the housing can allow an implant magnet of whatever shape to turn, possibly with some restrictions into the field lines. And then the specific embodiments of the specific shapes are introduced on the next page. That's page 8 of the patent and page 35 of the bundle. And the first is a spherical magnet, and I'll come on to why the experts were not attracted to that, but their first one is a spherical magnet, free to turn. Then they say in the next paragraph, instead of the spherical magnet, the magnet may be a variety of shapes. For example, it may be, without limitation, a cylinder. I mean, the author of this document could not have gone out of his way more, or her way more, to make clear that it's not limited to spheres and cylinders. And then we have what becomes, one has to keep a note on, is this line, the cylindrical magnet carries a magnetization being normal to its axis. And everyone agreed that means perpendicular to its axis. And that actually is diametrically magnetized. So what Zimmerling does teach is where you need to, and it has to with its cylinder, because it rotates like a rolling pin, you diametrically magnetize it. The other point about the cylinder is it shows that Zimmerling is not requiring perfect alignment. And there's no dispute that a spherical magnet gives you perfect alignment in that it can rotate in any direction. But as we've seen, Zimmerling consistently uses the phrase at least partially to align, because even if you cannot entirely eradicate torque, there's a benefit in alleviating it. And that's what he does with the spherical the cylinder magnet, because he puts it at an offset so it can deal with both the MRI in the closed bore, which goes head to toe, and the MRI in the open bore, which goes front to back. And he angles it at an angle to be able to at least partially align with both of those fields. Then at 20, even Zimmerling is implicitly perhaps accepting that the single sphere may be too large to get enough magnetic volume and remain clinically attractive. And so he includes these several smaller magnets, allowing for a thinner design. And that's the figure 4, and we'll come to those in a moment. And finally, my lord, just to make good my point on the claims, if you go to the claims, my lady, in page 45, they start with the switch embodiment, and we've seen the very familiar language, and no restriction as to shapes, the spheres and cylinders. They come in claim 2 and claim 4 of the switch embodiment. And then the claim to the torque reducer is, without the switch, is claim 13. And this is why I said we hadn't plucked language out from the depth of the specification. Not only has it been repeated numerous times, but Claim 13 requires a housing and a magnet free to turn in the housing such that at least one magnet is capable of aligning, at least partially, the external magnetic field. And I also draw my lady and my lord's attention to Claim 14, just on my learned friend's point that Zimmerling is also very concerned about keeping the attachment between the implanted magnet and the external magnet as perpendicular, which it is showing in all its embodiments. One sees in Claim 14, it is not saying that as something that's important for this invention. It just needs to make sure that the internal magnet can be magnetically attracted to the external one. Now, my lords and lady, if you one of the points that my learned friend makes great play of, yesterday and today, are the fact that Zimmerling uses these different shapes, so the sphere and the cylinder in its embodiments, and that it keeps the external magnet with an axial dipole. And this means that when connected together, so when the internal and external magnets are connected together, the dipoles will remain perpendicular to the housing. And he calls that the problematic perpendicular orientation. Now, one has to be careful with that, I'll come on to that. But starting with the shapes, it's not a mystery why Zimmerling exemplifies his spheres in the cylinder. There's no dispute that all else being equal, the best shape to use for rotation to align with an external magnetic field would be a sphere. But as I've explained, in 2010 all else was not equal, and that was the evidence for the judge because of the other design constraints. And Zimmerling himself, as I've shown you, has a nod to that because he has his three small spheres to try to keep the housing thin. But as I'll show you, there was evidence before the judge that that too was a problem. Also, he uses his embodiments, his spherical and cylindrical shapes, to perform a switching function that's no longer of interest, and of course those shapes are good for operating as a switch. Now, what about the temporary orientation of the dipole, as my learned friend puts it, his problematic perpendicular orientation when the two magnets are attached? Well, it does need to be remembered that this isn't a problematic orientation at all, and it's certainly nothing to do with what Zimmerling is concerned about. The problem of Zimmerling and the patent are directed to is torque on the implant magnet in the MRI. And the external magnet isn't relevant to that, it's not there. And both the patent and Zimmerling are teaching that you allow the internal magnet to align with those external MRI fields when the external magnet is not there. Now, when the external magnet is there in use, not in an MRI, one reason that Zimmerling keeps the connection between spheres or cylinders and the external magnet axial in its embodiments is because that's a perfectly reasonable thing to do, because it works with spheres and cylinders. I've shown you that his Claim 14 doesn't require it. But the fact that it works was explained by Professor Parker, and it's a little detail, but since my learned friend has made put so much emphasis on it, I would like to show it to you, and it's an easy way of explaining it. It's in the supplemental bundle, tab 15, page 158. And this is part of Professor Parker's second report. And my lady and my lord should have on page 158 a table showing what he was depicting was how the geometry relates to internal and external magnetic connections. And he shows two spheres in the middle table. And what he was showing there is that where you have spheres, rotatable spheres, they can be paired with either an axial or a diametric external magnet. He shows because they can rotate and fit the magnetic connection. So it doesn't matter, and therefore no reason to change anything externally. The same is true of the cylinder, and you see that at the bottom, two cylinders, and as he says there in the right-hand side, the cylindrical internal magnet can be paired with an external attachment or a diametric, so it doesn't matter. And then over the page, this was touched on yesterday by my Lord Justice Birss, I believe, that where you have the multiple spheres, that might depend on how closely packed they are. And this is a point I'll come on to. The problem with the sphere embodiment was you need to have enough magnetic attraction to attach to the external magnet, but not so much they interfere with each other. And that's one of the problems with that particular embodiment. But what he's showing here is that they can be used axially with an axial or diametric external magnet, although it may depend on how closely packed. Now, therefore, Zimmerling doesn't need to change for his embodiments the external attachment. The difference with the patent, and if one uses a diametric disc, I've already shown you that it's a knock-on effect, and the judge is finding on that. But one sees some reasoning here, technical reasoning, and if my lady and my lords would go back to page 156, explains why you have this knock-on effect, because from paragraph 29 he's talking about if one implemented Zimmerling with a disc-shaped magnet, and at 30 he says, well, the external magnet in that circumstance would need to be compatible with the internal magnet. It must be diametric as well. The skilled engineer would appreciate that the external magnet would require alteration, changing its dipole, i.e. diametric, to ensure a good attraction between the internal and external magnet and avoid any offset. And any offset in the alignment would lead to a corresponding misalignment between the transmitter and receiver coils and a reduction in the signal transmission and power coupling efficiency, which would be unworkable, and he shows there what he means by the offset. So the reason why it's a knock-on effect if you use a disc shape, diametric magnet, does not apply if one is using spheres and cylinders. And so it's not that surprising in my submission why one doesn't see Zimmerling making unnecessary changes to his embodiments. There is also a further reason why Zimmerling might keep his external magnet axial. It doesn't matter to the skilled person in 2010, but it's to do with the switching embodiments. And just so my lords understand the point, but as I say in our submission, by 2010, it doesn't matter to the skilled person, but it helps to explain perhaps Zimmerling's thinking. And if one goes in Zimmerling to figure 12A, and I've gone to 12A, but it's the same. I think my learned friend went to figure 8C, or 8, but it's the same idea. The way the switch works, the switching idea works, is, as my learned friend explained yesterday, you have two electrical contacts at the top, 1105, 1106, and on this one it has an electrically conductive surface which is hashed, and the idea is when in use with the external magnet, you see that in 12B, the axial nature of the attachment brings the rotating magnet up and connects with the two contacts. When the external magnet's not there and it goes into the MRI, then it rotates to parallel and comes away from the electrical contacts, and that was the idea of over-voltage protection. But one can immediately see that that's not going, for that to work, there has to be a change in state between the external magnet and the MRI. It wouldn't work if everything was diametric, because you wouldn't have it switching. Now that doesn't matter to our skilled reader in 2010, because he's not concerned with that, but it does show that there are reasons why Zimmerling did what he did, but they're not reasons that, with his embodiment, there's not reasons that constrain the skilled reader in 2010. So turning now, my lady and my lords, to how the judge dealt with this and my learned friend's criticisms, and if we take the judgment in Core 7, paragraph 196. And it's on page 124, on paragraph 196, he introduces Zimmerling. He introduces the overvoltage switch and says no one was interested in that by 2010, and he's right on that. And then he explains why he therefore hasn't spent too much time on that. But then he says the second aspect relates to, and there's the quote at the end of 196. Now that could not be a fairer summary of Zimmerling. I mean, what he's taken there is actually the words used in Claim 13, which is the claim that relates to that embodiment. And it's also how that embodiment was introduced by Zimmerling, and I showed you that at page 3, lines 13 to 16. No judge, in my respectful submission, could be criticised for summarising Zimmerling in the way that Zimmerling summarises itself. He then goes through the detailed description of the specific embodiments, some detail, and then we come to the part that my learned friend focuses his firepower on, which is paragraph 206. And we say it's entirely unfair. What my learned friend said was the judge wrongly here over-summarised and said the implant magnets can rotate to align with an external magnetic field. We say that's a fair summary, but also one can't just pluck one sentence out of a judgment and say it doesn't quite encapsulate everything it should. He was very clear at 196. He understood what Zimmerling was about. If the reader of the judgment wishes to see the other parts of Zimmerling, the judge has set them all out, the detailed description of the specific embodiments. And in the end, what my learned friend came down to in my submission yesterday was that what had been stripped out is what he called the problematic perpendicular orientation. And so the fact that the magnets, when together, not in the MRI, attach with axially. And we say, well, firstly, that's not a criticism. The judge here is setting out what is new about Zimmerling, and that isn't new about Zimmerling, so it's perfectly reasonable not to set that out there. And also, it's not a point that the judge overlooked. The point seems to be, well, he didn't put it there. But if you turn over to paragraph 212, he's completely clear. Zimmerling teaches that the external magnets, for attaching to the internal rotating one, all have axial magnetic orientation. Now that means when the rotating sphere or rotating cylinder attach, it's axial. And I've shown you that they can do that because they can turn. So there's no suggestion here the judge overlooked something. It seems to come down to he didn't put it in 206 in a way that my learned friend would like. Well, we say it's a most unfair attack on a judgment. Now, we pointed to our skeleton, paragraphs 47 and 49, that the summary by the judge actually accords very well with how both experts described the key teaching, and in a very similar way to how MED-EL did so when they talked about the key of the teaching in their closing. And I won't take you to that now, my lords and lady. You have seen that before. The point my submission is the reason why everyone was describing it, summarising it in essentially the same terms, That is what it says, and that is what the document tells you. And we say his approach to construction of the document cannot be altered. Now, my own friend then attacks paragraph 214 of the judgment with the phrase changing the orientation of the dipole. Zimmerling teaches changing the orientation of the dipole. And he says that betrays hindsight, because Zimmerling does not discuss changing at all. But one has to put that paragraph in context. This arises from the dispute before the judge about whether it was known that to get a disk to rotate in an external magnetic field, the dipole would need to be changed from the conventional axial, conventional in cochlear implants, to diametric. And that's what the judge had been discussing in paragraph 213. And I've already taken my lady and my lords to the end of that paragraph, where he held it was common general knowledge. But what he was discussing in 213 is MED-EL's case that it would not be obvious or common general knowledge to think that you could change the axial orientation of the dipole. So that's the whole context of the debate, and he held it was common general knowledge. Now at 214, that's why he starts the paragraph, in the circumstances, it may not matter if Zimmerling teaches effectively the same thing. And that's why he says teaches that changing the orientation of the dipole to one that is across the axis of rotation allows the magnet to turn. Now I've shown you that is indeed what Zimmerling teaches. It doesn't use the words change the dipole. What it does say is if you're using a cylinder that is, as it's explained, implanted parallel to the skin, you need to ensure that the dipole is perpendicular to the axis of rotation, so is diametrically orientated. And the point he's discussing here is meeting this argument that actually no one would know to do it. And our response was it's common general knowledge. He agreed with that. And our second response was that Zimmerling shows you. And that was the purpose of the cross-examination, where over the page I asked Professor Swanning, when I say he is already teaching there, I'm saying Zimmerling is also teaching there, the skilled person, to the extent they didn't already know, that in order to get this to work, and I was looking at the cylinder, he has to make sure that the shape is magnetized so it's able to rotate in the external field. Yes. And for this one, again, the cylinder, that means magnetizing diametrically, which is perpendicular to its axis of rotation. Correct. Now, that's why the judge says, well, it may not matter, because I found it common general knowledge anyway. But that's why he uses the language that he does. Now, finally, on this part, we have paragraph 215, and my learned friend criticises this because it contains an error, and the error is in the fourth line down, because the judge wrote there that all the taught orientations other than spheres, where it appears to depend, have the axis of rotation perpendicular to the skin. And that is an error. Now, our first point is one has to be extremely careful about criticising small errors in very long judgments, in my submission very well reasoned judgments, unless they actually had a knock-on effect to the reasoning. And my own friend hasn't pointed to any knock-on effect to this, because it's quite clear when he comes to Pozzoli, the judge knew the direction of the dipoles or the orientations in Zimmerling. So this is a sort of error without any effect. Now, looking at the error, my learned friend points to what was said in the form of order hearing, and where what happened was the judge, and it's in the transcript's in the bundle, but what happened was the judge was discussing my learned friend's grounds of appeal, and that the axis of rotation that what had been written here was wrong. And the judge made clear that it was an error because the dipole in Zimmerling is plainly perpendicular to the skin, which is true. Now, what my learned friends have done is say that that is effectively what he was doing, was drafting what should be in this paragraph. And therefore they delete axis of rotation and write dipole, and then say it still doesn't make sense because all the taut orientations other than the spheres where it appears to depend have the dipole perpendicular to the skin. And my learned friend says it doesn't make sense. In our submission, actually, it's much simpler. What went wrong here is perpendicular should read parallel. Very simple mistake to make when you're writing a judgment. I say this as someone who hasn't written judgments, but I suspect an easy mistake to make, because if you read this, that all the taut orientations other than spheres, where it appears to depend, have the axis of rotation parallel to the skin, that's correct. It also makes sense of the spheres, because that does depend. It also makes sense of what he then says, which is, I note that Professor Swanning believes the thrust of Zimmerling is to provide a solution that gives perfect alignment, but that is not done with the cylinder, and that is due to its axis of rotation parallel to the skin. It also makes sense of what I'll show you. He comes on to discuss the next page. So we say, in effect, the mistake here was writing perpendicular, not parallel, but in any event, it has no effect. And we see that over the page when we get to Pozzoli. And my learned friends have said in their paragraph 220, have said that he's gone wrong in approach or how he's directed himself in his application to Pozzoli, but from this side of the court, we cannot see why. He's identified the differences. Their issue, that they said yesterday, was, well, what he hasn't realised is that's almost the whole claim. Well, fine. In some cases, that will matter. But I've shown you why it doesn't matter in this case. And their real attack is how he deals with Pozzoli question 4, the last question, as to, are the differences obvious? That's not, in my submission, a point of principle. And as I'll show you, his reasoning not only was based on the evidence, but also the reasoning. Now, my learned friend did say yesterday that these images that we have in the middle of 221 are mysterious, and he said the purpose is unclear and it looks a lot like hindsight. And the judge is very clear that it's not. He says in the middle, third line down of 221, that it's just demonstrating the geometry point. It's not an acceptance. The skilled person would think of shortening the cylinder as shown. Wasn't his point. And it actually goes to the point we were just looking at in 215 with a small correction. Because what he's showing here is actually how geometry matters in this case, in the sense that the first image is a cylinder put as suggested in Zimmerling, although Zimmerling has it as a slight angle, but where, as the judge pointed out earlier on in that paragraph, the axis of rotation is parallel to the skin or the housing. It is diametrically magnetized so that it can spin, but nonetheless it is not within the claim because the dipole is perpendicular to both the skin and the housings. And that shows you that effectively not all diametric shapes would be within the claim. The second one he's showing you, this is if you had a disc but implanted it in a way that nobody ever implanted discs. But if you did, you would have a diametric disc, so that remains diametrically magnetized, but its dipole implanted would actually remain perpendicular to the skin or the housing. And then you have what the patent is talking about, which is if you have a diametrically magnetized disc and you implant it in the entirely conventional way in its housing, that is what the patent is talking about. You have a dipole which is parallel to the housing and the skin. So he's just showing that, and he's been very clear, he couldn't have been clearer, that it's just demonstrating geometry. So my lady and my lords, turning now to the finding on obviousness, and this was based on the evidence. The evidence of both experts was that a single sphere embodiment in Zimmerling would be likely to be too bulky to get enough magnetic material and would not fit within the flat, thin housings used by implants in 2010. And you've seen the evidence that no one was keen to do anything to change that because of potential clinical disadvantages of additional drilling, particularly with children. The problem with the cylinder was volume of magnetic material for attachment to the external magnet. It presents quite a thin magnetic surface at any one time, and of course requires a redesign. Now, Professor Swanning, Mellon and Friends client's expert, therefore focused on figure 4, which has the 3 smaller spheres which are said to enable a thinner housing, and as we'll see, that is what the EPO said would be done if you just read Zimmerling alone. What the EPO didn't have was the evidence before the judge that these were complicated to do, and I'm just going to show you 2 small pieces of that. My lord and lady, if you'd go to supplemental bundle tab 25. And on page 238, this is some cross-examination of Professor Parker, and he was asked at the bottom of internal page 406, line 23, at the time you wrote your second report, you were not suggesting that figure 4 would not work. As I understand it, you're not in a position to make calculations about magnet forces. Your point about figure 4 was that experimentation would be needed. And his answer was, I think it's much simpler than that. Having worked making these sort of magnetic links between the internal part and the external part and intrinsic understanding, it's difficult. It requires as much volume of magnetic material as you can get. And so, just by inspection, you can see that if you're trying to fill that space with spheres, you will not get the same amount of volume. And that makes the problem a lot harder. I would exhaust other alternatives before I even went down that path. And this problem of magnetic material was not only one that Professor Parker was grappling with, it was also one that in the end Professor Swanning had to acknowledge in cross-examination, and this is referred to by the judge in the judgment, so we can take it from there, and that is in core 7. Page 135, paragraph 244. He starts actually at 243 by saying that Professor Swanning didn't think you'd use the disc shape and instead would optimize figure 4. That was Professor Swanning's view. But then, as the judge records, and this came out in the cross-examination, he thought they would consider using different numbers of spherical magnets, so increasing the 3. And this is one of the parts where the judge criticised him. He said, in the context of giving his evidence, I find some of Professor Swanning's evidence somewhat inconsistent. For example, he did not feel the skilled person would consider using a disc-shaped magnet, but he viewed the fact the magnet used in figure 4a was a disc shape would be attractive and an advantage, obviously inconsistent. Another example was after lengthy cross-examination on what the skilled person would know about the basic rules of magnets and their rotation, Professor Swanning noted he believed the skilled engineer would only have a few days of lectures on magnetism, and I've shown you, he referred to that earlier. But in the end, that didn't matter, with later concessions. However, when discussing how to implement figure 4a, Professor Swanning noted that a move from 3-sphere arrangement to a 6-sphere arrangement may be better and would be obvious. The reason being to maximise magnetic volume, and it would be a common general knowledge arrangement of magnets using the hexagonal geometric efficiency of packing spheres in a plane, which he referred to as Kepler conjecture. He accepted all this would require work to assess the competing issues of magnetic volume and interaction between the different spheres. Now, leaving aside for the moment the inconsistency of a person going to a few days of lectures and then starting on a course on experiments with 6 magnetic spheres, leaving that inconsistency aside, what we do say as well comes from this is that in the end both experts were at one, but it would require a lot of work and there were issues with it. And you see that in 245, where he sets out Professor Parker's evidence that you could do 4A, but it would not be his top priority, and he's concerned about the complexity, the likelihood of failure. He then records, and I haven't shown you this, but it's here in the judgment, this was reflected in the evidence of the clinical experts. A clinical improvement would be necessary, although less of an issue if the regulators approve the design, but it's a balancing act. But standing at the start of that process, it would likely be an additional risk to the expectation of success. There are concerns about the magnetic volume of spheres for attachment purposes and interaction between the spheres. None of that, of course, was before the EPO. So then, why the disc shape? And the reasoning in the judgment we can take from paragraph 242 at first, and this is a criticism my learned friends make. And my learned friends criticise 242C. Now what he does here is he sets out Professor Swanning's view that there's no motivation to try the disc shape, that he said it would be a eureka moment to come across it and say, you can flip it, which is the dipole. His view, no one was thinking about anything other than axial, and no one was thinking about rotating. Then what my learned friend focus on is the judge saying, however, he accepted this type of rotation was taught by Zimmerling. And that's a perfectly fair way of writing it. The argument was whether it is obvious to rotate by changing the orientation of the dipole from axial to diametric. Flipping the dipole was a phrase used by one of the experts. And the judge records here that Professor Swanning accepted that that was taught in Zimmerling because it is, and it's the cylinder embodiment, and it teaches magnetising across the axis of rotation, not along it, and that is flipping the dipole from axial. So there's no criticism there. And then the reasoning of why one would, if one's a skilled person in 2010, prefer a disc shape. Well, on this, the judge preferred the evidence of Professor Parker, who had until 2007 been Chief Technology Officer at Cochlear. He described him as extremely open, helpful, and a good educator of the court. And my lady and my lords would have seen that he had severe reservations about the evidence of Professor Swanning. He sets those out in paragraphs 20, 49, and 213. He described him at times as being too controlled, coming across as slightly partisan, blinkered, he used the word evasive, and then at times contradictory. But this isn't a case of just a judge preferring one expert to the other. He also, very carefully in my submission, considered the reasons for the expert's opinion. And one gets a flavour from that if I just show these paragraphs, because my learned friend did not. If my lady and my lords would go to paragraph 233. He sets out the fact that there was a pretty extensive attack on Professor Parker by my learned friend's clients in closing. And he starts by saying the level of, on my findings, unfair criticisms levied at Professor Parker gives the impression there may be an effort being undertaken to try to avoid dealing directly with the evidence of Professor Parker. And then he quotes some of that evidence, and I'll show you some so you have a flavour just from the judgment of why he made the decision he did.
Professor Parker noted that when he saw, before seeing the patent and shown Zimmerling, he gave evidence about what he thought the skilled person would do, and it immediately struck him there were other straightforward shapes which could be used to take advantage of the rotatable design disclosed by Zimmerling. In particular, the first suggestion I made was using a flat disc-shaped magnet instead of the bulkier magnet shown in Zimmerling. The reason I thought of this is because flat disc-shaped magnets were the most commonly used type in the common general knowledge, and so the easiest way to implement Zimmerling would be to use the designs and components already being used. And of course, at the time of the trial, my learned friend's client's answer to that was, but you wouldn't know how to make them rotate. And that fell away. If one turns then to paragraph 240, he quotes Professor Parker's approach taking on the mantle of the skilled team. And if my lady and my lords would just read the part in italics. So, my lady and my lords, again, very clear reasoning about the and evidence about being highly motivated to use the disc shape. And finally, we have paragraph 248, where he quotes a part of Professor Parker's cross-examination. And he says, you have a magnet, and axially polarized magnets have been used forever. This is the italics in 248. So you know for a fact they have sufficient attractive force to hold a headset onto the skin. And stopping there, one can, in these sort of cases, get obsessed by the MRI compatibility. One always has to remember that the primary function of the magnet remains to attach together with the external magnet. And so you don't want to do anything that might hurt that. He said, now you flip the dipole of the field so it's aligned against, again, parallel with the coil or parallel with the skin, you know. You do not have to do much work to know that it will provide enough attractive force to hold the magnet onto the skin as one step. All other steps, of including Teflon as a lubricant or allowing it to spin, the magnet itself, the fact that it diametrically magnetized disc-shaped magnets are available, used industrially in other applications, all of that, I don't think it requires very much thought at all, in fact. Now, rather than going to those paragraphs, my own friend yesterday said the crunch came in para 246, so slightly one page back. And he had two criticisms as to what he referred to as the crunch. Firstly, this idea that it's a two-step. You have to make the disc shape and then to flip the dipole. And then he said it really amounts to throwing away Zimmerling. One has to be careful with this paragraph. In my submission, this is not the crunch. The crunch comes a little later. We'll come to it, paragraph 263, which my learned friend did not go to. But at this paragraph, the judge is actually, again, setting out the dispute. And it was indeed the dispute as to whether you think of using the disc magnet shape and whether you think to flip the dipole. So these aren't his findings, actually. He's setting out, again, the dispute. And on the point about throwing away Zimmerling, that's not the case at all in my submission. What's happening is applying the solution of Zimmerling to the very magnet shape and product which suffered from the problem. The real crunch point in the judgment is not a paragraph you've been taken to, and that is paragraph 263. What the judge says is in essence, he accepts AB's case on obviousness and the evidence and reasoning, not just the evidence, but the reasoning from Professor Parker. It is obvious to choose the existing common general knowledge disc-shaped magnet as one obvious option. He's very measured of a shape of implant magnet to progress in light of Zimmerling's teaching. Now his reasons, and he sets out the following factors. Firstly, it's a known entity. The shape is known to the skilled person. It's lying around on the desk, and that's a slight paraphrase of what was said by Professor Parker at T3-328. Secondly, it's known to have the required magnetic volume to attach the external magnet. That's a critical matter when that's what the purpose of the magnets are. And no or minimal extra work is needed. Thirdly, the choice of using the same shape as existing products would be motivated in part by the expectation regulatory issues may be more straightforward than a new shape. Fourth, using the existing thin shape would avoid the need for any additional risk of bone drilling. And fifth, the orientation of the existing assembly housing can be used along with the pre-existing system components. And stopping there, we say those are very powerful reasons. And certainly in my submission, no reasons for this court to interfere, and they are all reasons based on the evidence before him. Once chosen, he goes on, the teaching in Zimmerling or the common general knowledge dictates, brackets it is obvious, that the magnetization for the disc magnet should be changed to being across the axis of rotation to provide for rotation. The skilled person would have been able to appreciate the choice of magnet shape and orientation would provide sufficient alignment with the external magnetic field. And what he means there is the fields that we're interested in run head to toe or front to back, and where the disc is implanted in the side of the head is perfect for that. Based on the teaching in Zimmerling and the views of the experts, once the decision to have a disc-shaped diametrically magnetized magnet is reached, the rest is obvious and workmanlike and would be expected to succeed. And then he goes to the part I've shown you, that the external magnet is a knock-on requirement. And the end result is within the claim. My lady and my lords, we say that there is no discernible error of principle here. Now, before I move on to long-felt want, I will deal with the EPO. And for that, we need to go to the supplemental bundle, tab 27. And we can pick it up at paragraph 37, which is page 263 of the bundle. And as my Lord Justice Birss pointed out, that D2, which had diametric magnets, is...
Sorry, just before you get into the substance, can I just ask, so as I've got the chronology clear, this is the written decision of the 28th September. What was the date of the hearing?
I will have to put instructions on that.
The reason being, of course, that one assumes that in the usual way they would have given the answer on the day.
That I believe is right, my Lord Justice Arnold, but I don't have the date. I will get that for you.
Thank you.
Oh, apologies, having sort of sycophantically agreed. It's actually not the same. It is on the same date, and so apparently it was given down at the oral proceeding. Quite unusual. Yes. My Lord, the oral decision was 28th.
So that's the date. I heard what was said.
Yes.
So that's the date of the decision, and the written reasons will actually have come later.
That is right, and I can't find a date for that. But I can get that. I can get the date of the reasons for you, my Lord.
Yeah. All right. I understand. Thank you.
Apologies for the confusion on my part.
Oh, no, that's fine.
I was going to page 263 of the bundle. paragraph 37, where they introduce D1, which is Zimmerling, and they introduce it to say that it describes prior art disc implants as being susceptible to torque, which is correct, and they say it suggests as a solution to the problem that the implanted magnet be allowed to turn, possibly with some restrictions, into the external magnetic field lines. They've taken that, we've seen that phrase in, that's one of the passages in Zimmerling, but we don't have a particular quarrel with that, and proposes concrete solutions, employing, for instance, one or more magnets of a spherical shape. And again, there's no particular quarrel with that, that is what it teaches. We then my learned friends then turn to paragraph 42 to 44, where the argument is put about the general teaching, and 44 at the bottom, that making use of the general teaching and employing common general knowledge, the skilled person would implement an implantable device without requiring inventive skills. And the reasoning starts at 45, and we see it's all within the four corners of Zimmerling. The only information this teaching provides is the shape of the magnet is not important. We don't quarrel with that. As long as the implanted magnet can turn so as to line its dipole with the external magnetic field, and we don't quarrel with that because, of course, the evidence before the judge was a disc-shaped magnet, appropriately magnetised, can do that. Of course, it was different in the EPO because they didn't have that evidence. And what they said, went on to say, is the skilled person would seek in D1 itself, so would look in Zimmerling, for further information on how this could possibly be done, and would find the concrete solutions in the embodiments. They then consider the disc described in the prior art, so this is an axial disc, and it would not solve the MRI incompatibility problems because of the orientation of its magnetic dipole. Therefore, it would teach away. Well, again, we actually agree with that if you used an axial disc, as in the prior art, it wouldn't solve it. In fact, it would continue to tip, and you'd continue to have torque. What they don't have before them is the evidence that it's common general knowledge that you can, and you would know, to make it diametric. And then at 48, in the absence of any hint, this means in Zimmerling, but yeah, pointing towards it in D1, the skilled person would not consider changing the direction of the dipole. Now, again, the judge's finding, based on the evidence, was actually there's a very strong motivation to use the disc, and you know from your common general knowledge and basic physics that actually you can change the dipole. But it's right what they say here, that there's no hint to change the dipole of a disc. That is right, but we say the evidence and the approach was entirely different because of that evidence. And this is not to do with a different construction of Zimmerling, it's to do with how a skilled person, the knowledge a skilled person has when reading Zimmerling. And then my learned friend went to the next page, and this was the argument of paragraph 51, of flattening the magnet into a disc. That's not an argument that was advanced in the UK, it wasn't advanced before the judge. And so it's when they're addressing that argument, they look again in paragraph 52 that even if the skilled person would consider a disc, this solution would be disregarded for implying a return to the starting point. Well, that goes back to the fact that an axial disc magnet won't work. And that is correct. It's a different point about making it diametric. And then they say that the skilled person would take the solution of the three freely rotating spheres of the smaller diameter, which would result in a less invasive approach. And they feel, the EPO felt that was the way forward. Of course, I've shown you why the judge thought that would not be a way forward, at least certainly not instead of a disc, and I've shown you the evidence and why he did that. So we say this is a classic case of different tribunals come to decisions on different evidence. Of course, the EPO didn't actually have evidence, but they had Zimmerling. and they came to their own conclusion as to what a skilled person would do in light of the teaching of Zimmerling, and the judge was entirely entitled, and it's doesn't indicate an error of principle, that he came to a different end conclusion based on the evidence before him. My lady and my lords, unless you have further questions, I was going to turn to Longfelt 1.
Yeah, I'm sorry to keep on about the chronology, which in one sense it doesn't matter at all. But one likes to have these things straight in one's mind. I think it follows from where we got to earlier that neither party relied before the EPO on the judge's decision. So it's not just a question of the EPO not having had the evidence, the underlying evidence. They didn't have the decision either, although chronologically the decision would have been available.
I'll just check what they had. I don't want to say something that's not.
Well, certainly they don't say that.
They don't say they
and
had.
one might have thought they would have said that if they had had.
That may. What I don't want to do, my lord, is say something.
My instructions are they did have it, but my lord's obviously right, they don't refer to it.
Right, so, okay, they had it but ignored it.
We haven't got the minutes, have we?
We don't.
They're not in the bundle. I'm sure we can get them if they exist.
All right, not to worry. Thank you.
I've been instructed that they did have it, but it was filed too late for it to be considered.
Right.
And on the dates, my Lord Justice Arnold, the oral decision was given on the hearing on the 28th of September 2022. That's the oral decision without reasons. And the written decision was given on the 12th of December 2022.
That's very helpful. Thank you.
So, my lady and my lords, I was going to turn to Longfelt 1. I mean, the problem for my own friend is the position is, we say, actually, that there was no Longfelt want, and that's because the position was far more factually complex than he makes out, and the judge took that into account. The first point the judge mentions, and we say is relevant, is that this is not an industry-changing invention or anything of that nature. The competitors in the market, and even MED-EL, did not introduce rotatable magnets in products until quite a long time after 2010. I believe MED-EL was 2014, and other competitors 2018, 2019. And as was mentioned in the discussion with my learned friend, and is mentioned in the judgment at paragraph 260, the parties, including MED-EL, today successfully sell implants without rotatable magnets. And so one has to keep this patent in context. In relation to the position in 2003, when Zimmerling was published, well, it was quite different. And the judge recorded this in the beginning of the judgment at paragraph 60. And in paragraph 60, he's pointing out the fact that MRI use had grown, it had increased, and been continuing to increase, and continues to increase. There had been a slowing, but it had grown, and therefore skilled clinicians would be aware and be concerned about the increasing number of circumstances they would encounter where a patient has an MRI. So the point was it was a continuum going all the way through and getting more acute by 2010, and it's gone more since then. And the other point, and it's an important one, I'll show you a piece of evidence on that, is that in about halfway down that paragraph, the judge records it was a perceived concern by 2010 that the stronger 3 Tesla MRIs, which my learned friend mentioned yesterday, which were still relatively rare at the priority date, may be on their way to becoming more common. And Professor Crane explained that none of the existing implants available at the priority date were approved for 3T, even with the internal magnet removed, and he held that was common general knowledge. Just looking at, just to put a little bit of meat on that, it doesn't take long, in the supplemental bundle, page 206, which is tab 23. Actually, I think, sorry, I can speed that up actually and go actually to .216. Apologies, my lord. At 216, there's an internal transcript page 233, and this is the evidence of Professor Crane, who was my friend's client's clinical expert. And I asked him at the bottom, line 16, I said there's been a continuum, has there not, of increased use of MRIs before 2010, to 2010, carry on after 2010. And he said he'd agree that MRI use has increased over that period, although not common throughout the period. And I said it's increased, and the more it increases, the more issues with MRI become important. Correct. The more the use increases.
Not common, Mr. Nikonopoulos. It says common, not common.
Oh, sorry. I apologise.
You did read the rest correctly.
Oh, did I? I wasn't trying to slip something in. I just perhaps going too fast, and I apologise. The point I was making, though, is that as use increases, the more relevant it will become. Yes, that's over the page. And then the point about, I asked him about the 3T machines, which you saw the judge refer to, and his evidence was on page 208 of the bundle, sorry, 218 of the bundle, page 2440. At the end of 240, little page 240, I asked him, it's right that although 3T MRIs were increasingly common in 2010, but still rare, and he answered, I would agree with that. The standard was a bigger standard at Johns Hopkins, they certainly had them, but a lot of areas, a lot less common. But I said there was an appreciation or concern, depending on how you want to put it, in 2010, that stronger MRIs or 3T MRIs may be on the way, may be more common going forward. And he said, yes, we thought that might be the case. And in line 14, I said, I think you say in your report, nobody knew what would happen. But of course, if 3T would have become more common, then the existing ways of dealing with MRI compatibility, head wrapping and the like, just would not have worked. And he said, I believe that is true. Part of the issue at 2010 is none of the internal devices, even without the magnet, were approved for 3T, so our hands were kind of tied there. We did not have data on 3T with the cochlear implant with the magnet in, and I said if there was increased use of 3T, that's going to create a problem with existing devices because your hands are tied. And he said at the time we did not know. If I put myself back in 2010, I would say yes, basically our hands were tied. In fact, as it turned out, it hasn't been such a problem. So that is a very big difference in 2003. Now, this all arises, my lord, I think Lord Justice Arnold asked how it was put before the judge, but it all arises because Professor Parker, who had been a cochlear, explained quite fairly in his evidence that he had seen Zimmerly around 2003, 2004. He couldn't quite remember when, in a pattern search type of environment. And my own friend's clients then took that and, if I may say, ran with it, and they asked him questions about it, and they asked him whether all three players may have seen it similarly, and he very fairly, as the judge records, said, well, they probably would have done it in 2003, 2004. But the evidence of what he took from that and what a skilled person would take from that is quite important on this point, and that is set out in the supplemental bundle, tab 24. And you'll find it, my lady and my lords, at page 221A. And at 221A, he was asked about having seen it. This is page 293 at the bottom. And at 294, his answer, starting from line 4, was that he had been looking at it to be informed on what competitor companies were doing. He said, I wouldn't characterise my recollection of having seen the document before as indicating I had reviewed it. It was something I'd seen before. I don't recall paying very much attention to it. And then there was discussion, and he was asked about, well, what would someone think, or what did he think? And you get that over the page. At 297, line 6, he said, and this is internal page 297, supplemental bundle 222, apologies, I've switched there to. We did not actually look at Zimmeling other than the way I described it. It was something to look at, part of an overall kind of landscaping thing, to work out how much activity was going on. To say we looked at Zimmeling and then thought immediately we should go and build a similar thing, we did not do. And his reason, he gives in 298, line 9, where he says, I'm not trying to rationalise anything. I'm sorry, but I think what I'm saying is that what the intent of the paragraph is evidence was at that time, 2003, probably through at least the time that I left Cochlear, which was, my Lord's note, 2007. We were not at all interested in pursuing alternative solutions for better MRI compatibility, because our device already had a removable magnet, and I think it is well contained in that response. So they weren't interested back in 2003. And he was then asked specifically, well, what had changed? And he was asked that on supplemental bundle 224. Page 308, internal page 308. And the cross-examiner asked, if the skilled team would have seen that reading, seen Zimmeling in 2010, is there any technical reason why the skilled team reading Zimmeling in 2003 or 2004 would not have seen the same thing? So a technical reason. And he asks, you're asking if an individual reading it in one period, something may have happened in the intervening 7 years to give them guidance, change their view on it, and then we get the answer at line 23. The situation is that in 2003, 2004, competition in the market was very different than it was in 2010. The motivation of people doing design and development and product planning and so on was quite different. So I think you would look at things in different lights, depending on the environment in which you're currently living and working. But you asked very specifically, was there a technical reason? And he goes on, and how I interpret that to mean, was there a new piece of physics or some scientific discovery that would be different between 2003 and 2010? I would say no. This is very, very classical 16th century, 18th century physics. So the physics hasn't changed, but the motivations of the skilled person reading it had changed. We say that matters and is crucial when considering a point such as long felt want and why was the next step not taken before. Finally, going to the judgment, and the judge dealt with this page 136 of the bundle. He starts, we say perfectly properly, setting out the case law, and there's no suggestion he missed something out or didn't get that right, and of course he refers to Halliburton at para 251. He then, at 254, records the evidence on this point is fairly light touch. Effectively, it was trying to be based on the fact that Professor Parker had seen it. And then over the page, as was said earlier on, he sets out at 258 various factors at play. Now at 257, the point my learned friend relies on is he does point out that Zimmerling had been picked up by Cochlear around 2003 in a pattern watch that hadn't been considered any substance, Professor Parker. He had, of course, no evidence as to how other parties may have looked at it if they did, other than Professor Parker helpfully assumed it would be the case. But he said that's not enough to support the contention the document was well known to all relevant parties. Well, that must be right. But he doesn't then say, well, that's the end of it. He does say, well, the contention on long-felt want is looking difficult. And in my submission, having seen the evidence, and I've shown you the evidence of Professor Parker, that's right. Then he goes on, and in 258 explains why there isn't indeed a long-felt want, because of all the other factors at play. And he sets out the various factors that I have shown my lady and my lords this morning. And he ends by explaining at 260 that in any event it would not have altered his view on the primary evidence, because he obviously took the view, and we say rightly, of the strength of the obviousness case. And you see that it would not have been enough to change my final assessment on obviousness. But he's very clear that he's taken all the factors into account, and it's not a case where there was a piece of prior art that everyone or people had seen 7 years before, and there's no reason why the obvious was missed. That's not this case at all. My lady, my lords, unless the court has more questions, those were my submissions on the appeal.
Thank you very much. Mr. Speck.
4 short points in reply, if I may. The first is this. My learned friend identified, I think it was 3 factual matters at the outset, and his third one was that when you choose which orientation of your magnet and the internal magnet, it is a knock-on effect what you do for the external magnet. I think that was his third point. And there's nothing between us on that, but it's not an answer to my point. Because my point is that when you decide to change the internal magnet, you're deciding to change the arrangement of the attachment, which you don't think of. So he's tried to say that you're changing the attachment because it's a knock-on point, and he shows you evidence about it being obvious. But the starting point of that is that you've decided to change the internal magnet, and my argument is directed to getting to that point. And I totally accept that you have them matching. The argument is about whether you choose to go to that. So that's not an answer to my point in my submission, although he tried to make it look as if it was. The next of my points is related to the whole idea of Zimmerling teaching changing the orientation of the dipole. And you will have seen that that was discussed in the judgment, and that my learned friend sought to maintain that in his skeleton argument by saying it does. The argument that was put didn't seek to maintain it. The argument that was put is that you get it from common general knowledge. Quite a distinction, my submission. He is not now saying that there's Zimmerling teaches changing the orientation of the dipole. Indeed, when we got to the EPO paragraph, he even said he had no quibble with the paragraph in the EPO decision that says there's no hint of it. It's the same point. What he's now seeking to argue is that you think to do it and know how to do it because of your knowledge of common general knowledge. And that's a very different thing, and actually is shifting right back from saying that there is this idea in Zimmerling, which is the way in which the case was put before and even maintained in my learned friend's case and argument. Point 2, my 4. The third point is paragraph 215, the error that the judge agrees is an error. And in my submission, the submission that my friend made was quite extraordinary because he's realised that the explanation that the judge gave at the time is untenable, and he's come up with a new one on his feet, that in fact what was intended was something quite different. What the judge explains, and I'm going to ask you to turn it up because I told you what the judge had said without taking you to it, and my friend didn't go to it either. So it's in the supplementary bundle, tab 28. It's page 100 of the transcript. So I'm not sure whether my lady and my lords have got, oh yeah, the pagination, I've got a separate version. So it's 273 of the bundle, top left-hand side.
I think you did take us to it, because I've marked it up.
Oh, did I? I told you where it was, I think.
Perhaps I just looked it up anyway then.
I think you might have been being diligent. Apologies if I'm ramming it home again. I told you what was there. I'm sure of that. And the point is that the judge explains that what's in that paragraph is wrong. He suggests it's an obvious error. And you see between lines 11 and 14, he's telling you what he means. I should say it's an obvious mistake on my judgment. Quite clear from the context that the dipole is perpendicular. As my Lord Justice Birss not... You got it?
Not yet.
Right.
On page 273, which
273, so it's page 100 of the transcript,
okay.
in the manuscript, and it's basically all the way down to about line 14, but the key lines are 11 to 14, where the judge is suggesting he's got an obvious error, and he's explaining what it should be. Quite clear that the context that the dipole is perpendicular, and now my learned friend disclaims that and says actually what the judge was saying is he's got it wrong and it should be corrected, and say
I'm sorry, can I ask another irrelevant question, but I'm trying to get the chronology straight. Were there two forms of order hearing in this case? Because the actual order that the judge made is dated the 21st of September.
My Lord will appreciate I wasn't there, it wasn't me at the time in this case. I think I've been told that there was a big argument about costs. The judge reserved his judgment, and in fact, in the end, they settled the cost dispute.
Right.
So there was a delay between the formal order hearing and the actual order.
Right.
But there was only one formal order hearing.
Jolly good. Thank you.
But you can. What I'm drawing attention to is that the explanation given by the judge is not the one that my friend has just given to my lady and my lords that stood here.
But does it work, his explanation?
His explanation doesn't work. And that was my complaint, is that he's...
No, sorry, I meant your opponent's explanation. Suggested explanation.
It might work. It might work because he keeps axis of rotation and changes perpendicular to parallel. It might work. Whereas the judge says he's changing it to the dipole here.
Yes.
Yeah.
Thank you.
My final point is just simply this. We still are none the wiser as to what the point, the geometry point is in paragraph 221. My friend just said it's okay because it's describing geometry, but it's completely pointless if it's not actually suggesting that it's some route to get into the flipped over disc with the flipped magnet. He didn't really have he didn't have an explanation as to what the point of that was at all in our submission.
So I'm a little unclear as to where this submission goes. Let me test it in this way. Imagine that the judgment didn't contain paragraph 229. What difference would that make to the judge's reasoning and conclusion?
The difference is this, is it looks, the real reason it's there is to get you thinking about doing that. He says he's not doing that, he's not saying that that's what the skilled person would do, but that's the real reason it's there. You salami slice the cylinder, you look at that and then you flip it. It looks and is redolent of a hindsight step-by-step approach. It's been inserted into the judgment and it betrays that that's the thinking. And there is no point to it. To say it's just illustrating a geometry point but then not being able to identify what the geometry point is not good enough in this.
Mr. Speck, if it didn't have the middle diagram of the three, and I appreciate it does, don't worry, I get that. With the top one and the bottom one, what it's illustrating is the difference between what's in Zimmerling and what's in the invention. Isn't it?
I do understand.
I appreciate your point is that it includes the middle step and that's the step.
And also what you're postulating is an explanation of what the geometry point is.
Well, it is an accurate. The top one is an accurate picture of Zimmerling, and the bottom one is an accurate picture of the pattern.
Exactly, but there's some.
I understand. There's a bit in between. I get it.
Yeah, and also it's said to be there's some geometry point. What is the geometry point? I mean, because really, what your lordship is just saying is it shows.
What's the geometry point shown? What I am saying. What if it's just really trying to show the geometry relationship between Zimmerling at the top, the patent at the bottom? How a more canny judge might have deleted the one in the middle to stop you from making the point. What the judge did do was produce a diagram which he'd been given and specifically made the point in the paragraph that he wasn't demonstrating a step-by-step approach.
I understand the point my lord's putting to me. One could say that. One would then just ask, why don't you just reproduce the cylinder from Zimmerling and the well, you've got the big diagram earlier on in paragraph 45 of the diametrically magnetized magnet anyway. It's doing more than that, my lord, in my submission. It's showing a step-by-step between one and the other, but without explaining what the point is if it's not what I'm suggesting. Those are the 4 points that I had noted. Can I just check in case there's anything else that I should say to you? There's nothing else on